So thank you for the introduction, and also thank you for inviting me. Uh, I'm gonna start by sharing my screen. So I'm gonna be talking about lawyer ethics in virtual courtroom, and in the course of my presentation, I'm basically gonna be talking about just some selected ethical issues lawyers need to give serious consideration as we move from in-person litigation to e-person litigation. So first, I'm going to start with technological competence. Uh, as lawyers, one of our primary duty, professionally speaking, is the duty of competence. The Law Society of Alberta's Code of Conduct imposes an obligation on lawyers to be competent or to competently perform all legal services undertaken on the client's behalf. And a competent lawyer is defined as a lawyer who applies relevant skill and knowledge in a manner appropriate to the matter undertaken on the client's behalf. So there is a duty on lawyers to be competent in discharging their duties, their responsibility to their clients. And considering the time we our current practice at this point in time, that duty of competence, of course, requires lawyers to be very familiar with audio and video conferencing technologies, among other legal technologies, which are very relevant in the practice of law in this time of the pandemic. So lawyers have a duty to familiarize themselves with these with these technologies as well as legal technologies. It is part of our ethical duties to be competent. And this is also important because legal technologies will continue to be relevant to our practice even after COVID, that is post-COVID-19. Whereas the duty of technological competence is not explicitly provided for in the Code of Conduct so far in any province or territory in Canada, the Federation of Law Societies of Canada has actually amended the model rule of professional conduct to include the duty of technological competence. So it is very important for the various provincial and territorial law societies, especially the Law Society of Alberta, to also amend the existing code of conduct to impose an obligation on lawyers to be technologically competent, because that is one skill. Technological skill is one skill lawyers will need to be able to navigate the difficult legal practice, both in the current COVID-19 pandemic as well as the post-COVID-19 era. Another important ethical issue I would like to discuss is e-hearing and the best interest of the client. Now, there's no doubt about it that electronic hearing comes with a lot of benefits for the client. The efficiency, the effectiveness, the cost efficiency, among many others. But at the same time, it is important to know that it is not every case that is proper or suitable for e-hearing. Cases where the demeanor of the witness is important, cases where or cases that are built on physical as opposed to electronic evidence may not be suitable for e-hearing. So as a lawyer, you have an obligation to study the nature of your client's case to determine whether e-hearing or electronic hearing will actually be in the best interest of your client. Unfortunately, Rule 6.10 of the Alberta Alberta Rules of Court allow for a situation where part of a case could be had partly by electronic hearing and partly by other means. So when you have determined that e-hearing is in the best interest of your client, does that mean then that, okay, you go ahead and use that as, apply e-hearing or utilize e-hearing? Well, before doing that, it is important to remember that as a lawyer, the client actually is the boss. The case belongs to the client, not to you as the lawyer. So even if the e-hearing is in the best interest of the client, it is important for you to also communicate this to the client, obtain the consent of the client to use e-hearing rather than going ahead without taking the client along with you. And this is important because some clients actually may prefer to have their day in court and not in Zoom. So if the client, even if you think the e-hearing is in the best interest of the client and the client refuses to go by that means of hearing, you have an obligation to follow the instruction of the client, except if the client is being unreasonable and the unreasonableness has gotten to the extent where there is a serious loss of confidence, which of course the rules of conduct or the code of conduct gives you the opportunity or the discretion to withdraw from representing the client where the client is unreasonable or being unreasonable. Now, another important ethical issue I would like to consider is communicating in the virtual courtroom or communication in the virtual courtroom. Now, there are risks, especially privacy risks, that comes with use of technology, even in the virtual courtroom. So it's important to guard against these risks so that you do not compromise confidential information or client confidential information. And this is because virtual courtrooms, they normally have confidential information for you to be able to gain access to it, like meeting ID and password. If these are in your possession as a lawyer, you have an obligation to keep them confidential so that individuals who are not supposed to be in this virtual courtroom do not find access to the courtroom so as to disrupt the proceedings or to have access to confidential information that they are not supposed to have access to. Also remember, like when you're communicating with the client, for example, in Zoom, you have a privacy function whereby you can communicate privately with another participant, assuming the other participant, in this case, the client. Now, it is important to know that notwithstanding the information is said to be private, at the conclusion of the proceeding, those private chats or private communication forms part of the bigger transcript of the entire proceeding. So be careful about exchanging confidential information or privileged communication using this function, because you may eventually end up losing those privileges because of disclosure or public disclosure of such information. Then you talk about also inappropriate communication. And inappropriate communication here, I think what comes to mind here will probably be cross-examination of the client or maybe your client. And this is important where maybe you are sitting in the same room or in close proximity with the client while the client is being cross-examined. You have to be very careful so as not to engage in inappropriate communication with the client during the course of the examination, such as whispering answers to the client. And this was actually the situation in a very recent case, the Law Society of Alberta and Ade Lowoken, where a lawyer was reprimanded by the Law Society for whispering answer to the client while the client was being examined in a refugee hearing by a member of the tribunal. And another important point is etiquette. Please, in virtual courtroom, dress appropriately. And when I say appropriately, I mean from head to toe and not from head to the waist. And this ABC news reporter actually learned that lesson in the hard way. This is because sometimes even when you are dressed up, the video camera may just get up to your mugshot. You may need to sometimes stand up and move around. So you may eventually end up, if you're not appropriately dressed, you may end up actually revealing some parts of your body other members or other participants in the proceeding may not want to see. In virtual courtroom, please endeavor at all times to observe all normal court etiquette and procedure. Be conscious of your conduct at all times, even when you are muted or when the video is turned off. I often encourage people in virtual courtroom to give themselves the impression, even when the video is turned off or when they are muted, to conduct themselves as if they are not muted or the video is not turned off. This is because sometimes you don't know when you are muted or not. So it's important to avoid what CNN, Cable News Network, referred to as supreme embarrassment, which was what occurred during a U.S. Supreme Court teleconference hearing, where one of the participants actually went to the toilet with the computer. It was not muted, and then flushed the toilet after using it. The flush was heard by everyone, every participant on that audio conference. CNN referred to it as a supreme embarrassment. So try to avoid such a situation. And also, lastly, use appropriate background. A neutral background, it's highly recommended. Now, having said all this, I would now like to go back to the initial issue I talked about, which is technological competence. And this is related to what is going on currently in my law school, which is the University of Calgary Law School. Our objective have always been to train law students for the profession they will join, not the one we joined. And this is because the profession or the legal profession our students will be joining will be radically different from the one we joined many years ago. So this requires on our part as professors to be able to foresee what are the changes or emerging changes in the profession, anticipate the future, then train the students accordingly so that when they leave the law school and go into the world of legal practice, they are able to immediately fit into that society and adapt into that legal environment. So currently, I'm designing an e-litigation course, which is aimed at training students to be practice ready in a COVID-19 and post-COVID-19 legal environment. So my e-litigation course aims to train students to be able to conduct full litigation electronically from beginning to the end. So this, of course, include 3 different phases: e-filing and e-service, where the students are exposed to filing and service of commencement documents electronically. Then e-discovery, which deals with review, search, review, and of course, disclosure of relevant electronic documents to the opposing party. And finally, e-hearing or e-trial, which deals with the conduct of the trial electronically. So the idea of the e-litigation course is to dispense with in-person litigation. And this is, of course, very necessary and essential in the era and post-era of COVID-19.